Okay. Mark, we're going to take a listen inside the courtroom right now.
Very well, ladies and gentlemen of the jury and also the alternates, you may be seated. And you have sent the court a note indicating that you other than count 6, which you had previously rendered a verdict on, you're unable to reach a unanimous verdict on the rest of the counts. And you sent me that. Is that correct, Ollie? Okay. And Harlow, let me give you that. You can make that part of the record. Okay, let me just ask you this. It's customary for the court to inquire if there's a possibility of reaching an agreement within a reasonable time, and in this case, a unanimous verdict. The court will therefore submit this question to the foreperson with instructions that the answer be either yes or no, and do not disclose any other information nor indicate the status of your deliberations. And my question to the foreperson is there a possibility that after an additional period of time, today or even tomorrow, that you may reach a unanimous verdict on the remaining counts other than count 6? Okay. Very well. What we will do now, I understand that. What we will do now is I will ask Mr. Tidd, our clerk, to read the verdict which you previously rendered, and you were polled on that. And I'll ask Harlow, Mr. Bloom, if you'll open that envelope and hand the verdict to Mr. Tidd, who then will read the verdict. It's been previously entered, but he'll then read the verdict as it will be recorded.
Please the court. Ladies and gentlemen of the jury, you will now hear your verdict read as this court will order it recorded. Verdict. Count number 6. We, the jury, and the issue joined, find the defendant, Tracie Hunter, guilty of having unlawful interest in a public contract, RC 2921.42A1, as charged in count number 6 of the indictment.
Okay, thank you very much. And Harlow, this verdict has been previously entered, but we'll give that to you to enter that as part of the record. Okay. Very well, ladies and gentlemen, that will end your service in this case, and I just might tell you that you were absolutely super. I realize that you could not agree on the remaining counts, but you did agree on one count, for which we thank you. You were absolutely super. You showed up all the time. We weren't always timely, but you folks were. You spent 6 weeks of your life, and you deliberated. I should say, you have considered this case for a considerable length of time. The court accepts your response that you are unable to reach a verdict on the remaining counts other than 6. The court accepts this conclusion and finds that there is no probability of the jury agreeing. So that will end your service. We do thank you. You were absolutely super. You were always timely, and you gave up 6 weeks of your life. This is a 6th week. You start deliberating. You deliberated Wednesday for a half day. You deliberated Thursday, you deliberated Friday, and you deliberated for about half the day today. So, I mean, you were absolutely super, and we appreciate it, and we really thank you from the bottom of our hearts. And the other thing, I do want to say to those of you, to the jury, you're free to talk about it, but I wouldn't if I were you. You can talk to your family, you can talk to very close friends, but this was a high-profile case. with a lot of people on one side, but you decided, at least count 6 you did, and you decided on what you heard in the courtroom and not what others have said outside the courtroom or may say. You did a super job. You gave us a verdict. You gave us your best shot, and we deeply appreciate it. The attorneys in this case were absolutely super. You saw the special prosecutors, and they're not prosecutors. They're Mr. Shivadecker was previously a prosecutor, but he's been a defense lawyer for decades. Mr. Croswell for decades has been a defense attorney. Mr. Bennett was absolutely super. He's one of the best criminal defense attorneys that I've ever seen. He really is. He's super. He did his job. There was a lot of back and forth, and which you would expect, a lot of lost tempers and everything else, but I did instruct you on that, and I'm sure you didn't hold that against one side or the other. These are very fine gentlemen on both sides. The attorneys are 3 very, very fine gentlemen, and they did a great job, and you made a decision. We will, and I'll go, after I discharge you, I'll go into what will happen further. But there will be a date of sentencing probably in December sometime, and then the special prosecutor can decide whether or not they want to retry the remaining counts of the indictment. So I can't thank you enough. I wouldn't, again, you're free to talk about it to your family, to maybe close friends, but I wouldn't talk publicly. This has been a controversial case. A lot of people on one side, people on another side, but you were the ones that made, on count 6, you made the ultimate decision because you did it on what you heard in the courtroom, and you were unable to agree on the other counts. And I respect that because I know you gave it a good shot. I know you were back there, you deliberated, what we say, half a day Wednesday, Thursday, all day Friday, and half a day today. I think, and you indicated to us that you couldn't reach unanimous decisions on the, I respect that, and I thank you. You did a great public service, and I thank you from the bottom of my heart. And I know the parties thank you too. So you're excused now, and court is still in session. The jury has already been polled, so they were previously polled, and that's it. They were polled last Friday. No, they were polled, and they were asked whether count 6 was their true and verdict, and they all indicated yes. So it's over, and I indicated that. Okay, folks, you're excused with the thanks of this court.